Okay, we're going to do a 200 minute jury charge. Ready? If you believe that any witness testified falsely concerning any material fact and did so with the purpose to deceive you, you may give to that witness's testimony whatever weight you deem it is entitled. You may, in your discretion, disregard all of the testimony of that witness, or you may choose to accept some parts of the testimony and reject others. You may also consider any explanation that a witness may have given for an inconsistency or a discrepancy in the testimony, and you may, of course, accept all of the testimony of any witness. Evidence has been presented during the trial that the defendant has been previously convicted of a crime. Conviction of a crime here is one of the two elements of the crime charged, that is, being a convicted person in possession of a weapon. But essentially, conviction of a crime may be considered only for the purpose of weighing and evaluating the credibility or believability of a defendant's testimony. You may not use the fact that the defendant's prior conviction should serve to conclude that because he previously committed a crime, he must have committed the crime charged here. As judges of the facts, you have a right to consider whether a person who has previously failed to comply with society's rules as demonstrated by a criminal conviction would be more likely to ignore his oath requiring truthfulness than would a law-abiding citizen. In weighing the effect of a defendant's prior conviction, you may consider when it occurred. You may consider the prior conviction of a crime to be of importance in weighing the credibility of the defendant, or you may consider it or find it to be of no import at all. It is critical, however, that you remember that a prior conviction may be used only for the purpose of weighing the defendant's credibility and not for the purpose of concluding that he is therefore guilty of the crime charged. You have heard questions revealing that the defendant, Mr. Smith, is represented by attorneys from the Office of the Public Defender. Such questions and disclosures are inappropriate because they may cause you to believe that the defendant is less worthy of privately retained counsel, or it may create an indignation that someone who is charged with a crime is being defended at the taxpayer's expense. Such thoughts or perceptions are inaccurate and unfair. Mr. Smith is represented by the Office of the Public Defender because he lacks the funds to retain private counsel. If he had the funds, he would be required to retain his own attorney. The Sixth Amendment of the United States Constitution provides that anyone who is charged with a crime, regardless of the nature of the crime charged, is entitled to be represented by counsel, and that right to counsel applies to the indigent or people of lesser means just as it does to the wealthy. Thus, whether rich or poor, powerful or weak, every citizen charged with a crime is entitled to legal representation. Therefore, whether Mr. Smith is represented by private counsel or a public defender is of no consequence and must not be considered by you in your deliberations. Evidence in a trial comes in two forms. It comes in the form of direct evidence and circumstantial evidence, and the law doesn't favor one form of evidence over another. But because non-lawyers think circumstantial evidence means unreliable, the court has previously given you an illustration or an explanation explaining the difference between those two forms of evidence. You'll recall the court explained about the snow falling. Is there anyone who would like that illustration repeated? I see no request for it. Any fact or group of facts may be proven by direct evidence or circumstantial evidence, provided, of course, here in a criminal case you are convinced beyond a reasonable doubt. The parties have agreed to a certain fact, that is, they have entered into a stipulation. It is agreed that the defendant, Mr. Smith, has previously been convicted of a crime enumerated in the governing statute, which means that he is a convicted person not to possess a firearm. The jury should treat this fact as undisputed, that is, that the parties agree that the fact is true. As with all other evidence, an undisputed fact can be accepted or rejected by the jury in reaching its verdict. The defendant, Mr. Smith, is charged in the indictment with being a certain person not to possess a firearm, it being alleged that on September 5, 2012, that he, having previously been convicted of a crime, possessed a firearm, that is, a pellet gun. The governing statute provides any person having been convicted in the state or elsewhere of a predicate offense, and he has stipulated to that, who purchases, owns, possesses, or controls a firearm is guilty of a crime. In order for you to find the defendant guilty, the state must prove each of the following elements beyond a reasonable doubt. 1. That Exhibit S-17 is a firearm. 2. That the defendant purchased, owned, or possessed or controlled the firearm on September 5, 2012. And 3. That the defendant is a person who previously has been convicted of a predicate offense. A firearm means any handgun or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectable ball, slug, pellet, missile, or bullet by means of a cartridge or a shell. An operable pellet gun falls within the definition of a firearm. We say that a person acts knowingly if they act with an understanding of what it is they are doing and with an appreciation or an awareness of the consequences of their conduct. Knowledge is a condition of the mind. It cannot be seen. It can only be determined from inferences to be drawn from a person's words, acts, or conduct. A state of mind is rarely susceptible of direct proof and must ordinarily be inferred from the facts. Therefore, it is not necessary for the state to produce witnesses to testify that an accused said that he had a certain state of mind when he did a particular thing. It is within the power to find that such proof has been furnished beyond a reasonable doubt by an inference or inferences which may arise from the nature of the defendant's acts, conduct, and from all that he said and did at a particular time and place, and from all of the inferences shown by the evidence. To possess an item, one must have a knowing, intentional control of the item, accompanied by a knowledge of its character. A person who possesses a firearm, in this case a pellet gun, must know or be aware that he possesses it, and he must know that what it is he possesses or controls is a pellet gun. In other words, to possess means the defendant must knowingly procure or receive the item possessed or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. A person may possess an item, in this case a pellet gun, even though it is not physically on his person at the time of arrest, or if he had in fact at some time prior to arrest had control over it. It's a little over 6 minutes.